Now we move on to the 2023 International Law Association ILA Arbitration Dinner and Awards with the theme International Arbitration, Putting Our House in Order. Leading arbitration practitioners who spoke at the event called for a significant change in attitude towards accountability and integrity within the profession. We have more details in this next report.
The dinner, which held in Lagos, attracted members of the bench, senior legal practitioners, members of the arbitration community, and many other professionals. The president of the International Law Association, senior advocate of Nigeria, Professor Damilola Olawuyi, who joins the event virtually, invited more professionals to join the arbitration community. He also spoke about the importance of aligning arbitration practices in Nigeria with international standards and best practices.
In my own personal practice, I see arbitrators traveling to London, Geneva to resolve disputes that originate from Nigeria. And I think this should worry us, and this is probably one of the things we should reflect on tonight. Furthermore, recent events revealing the tendency of arbitrators to abuse the confidentiality of arbitration to perpetuate brazen conflict of interest and corruption should worry us as well. I think this event should be an urgent wake-up call for us to ensure that arbitration does not become a vehicle for corrupt parties to prove their crimes in the respectability of the institution of arbitration. Also, challenges of costly procedural delays using technicalities to derail the enforcement of arbitral awards and lack of clear training opportunities for young arbitrators are challenges that should indeed worry us as arbitrators, and we should think of ways to resolve them. I hope we will take the opportunity of the dinner to have some very frank discussions on how we can clean up the practice of arbitration and make it even more respectable than it currently is, especially making Nigeria a respectable seat of arbitration in the near future.
The representative of the ICC, in her goodwill message, also stressed the need to collaborate and bring dignity to the affairs of the arbitration community.
Indeed, we are in the times when we need to talk frankly with ourselves, when we need to really help in our engagements to bring about some kind of dignity in the profession that we are operating in.
The host, the chairman of the arbitration committee, Mr. Tolulokwe Aderemi, took center stage in advocating for change. He highlighted the decline in the reputation of arbitration practitioners and emphasized the need for a universal code of ethics.
As you will agree with me, this arbitration community has come under severe scrutiny, and that is why we're all here tonight, whether for legitimate concerns or otherwise. Either way, I am proud to say that Nigeria boasts of some of the best minds with exceptional intelligence, diligence, and persons of unquestionable character. However, it will seem there is a gap. We have no accountability partner. Our accountability partner may come in several forms. On this occasion, it may come in the form of a national code of ethics. The Chartered Institute of Arbitrators, the CPR Institute of Dispute Resolution, the National Academy of Arbitrators, and many others. They have provided simple guidelines tailored to specific domains. However, what we need is a universal code of ethics that addresses misconduct and its consequences. A most recent one is the infamous case of the Federal Republic of Nigeria versus the Process and Industrial Development Limited, the famous P&ID case, which has challenged our integrity and reputation as arbitration practitioners. Do we have a collective response to this? I am referring to the decision of Honorable Justice Robin Knowles of the London Commercial Court, a decision which will be referenced in every arbitral challenge under Section 68 as long as the Arbitration Act of England 1966 remains in force. It is also true that if we do not act fast and put our house in order, arbitration may become less reliable. It is also true that we need to introspect what went wrong with that contract, or indeed other contracts. What went wrong with that arbitration, or indeed other arbitrations? What is this community's attitude towards misconduct and the removal of its reference in the new Arbitration and Mediation Act, AMA?
The keynote speaker, Mr. Babatunde Fagbohunlu, SAN, who also joined virtually, delivered a speech on international commercial arbitration, putting our house in order. He focused on the challenges faced by African arbitrators in accessing the global arbitration market and the significant arbitral awards against the Nigerian government. He also emphasized the need for Nigerian arbitrators to equip themselves for global opportunities while proposing the establishment of a single arbitration institution for the African continent to enhance its attractiveness and participation in international arbitration. This was followed by a fireside chat with Life Bencher and the first female Attorney General and Commissioner for Justice, Lagos State, Mrs. Hairat Balogun, who, amongst other things, addressed the ethical issues plaguing the legal profession.
The goal of educating lawyers is purely on the laps of the Council of Legal Education. Who are members of council? Most of them are deans of law.
The event also provided an opportunity to honor some deserving individuals for their contributions towards the development of the arbitration community. Those honored were Mrs. Hairat Balogun, former chairman of the Arbitration Committee of the ILA, Mrs. Adedoyin Rhodes Viver, the chairman of Heritage Bank, Akin George Taylor, and the Attorneys General of Lagos and Oyo State.